before you today on State versus Thomas Tortorella, files 26 CR 224 and 26 CR 225 are here today for sentencing. State of Ohio has had the opportunity to review the pre-sentence investigation report and is prepared to go forward. Thank you.
Mr. Mulkey.
Thank you, Your Honor. We are ready to proceed. Your Honor, Mr. Tortorella is 61 years old. After talking to him and reviewing his pre-sentence report, he certainly has had a challenging life, to say the least, starting with his childhood. There's an indication of that things were not well in his household. I think there was some mention in there about being exposed to alcohol back when he was very, very young. He's been exposed to drugs his entire life, Your Honor. As it relates to the facts of the cases that bring us here today, driving under suspension, those stem, unfortunately, from an aggravated vehicular homicide for which he served 9 years in prison. Your Honor, he was in prison times before that, so he's no stranger to the prison system and the prison culture, Your Honor. He'd like to do something to rectify that. Hopefully, with the fact that he was driving, I think in one of these cases he was going to get something to eat and helping a friend move a vehicle. But as he has stated to me, and I think he's put in his pre-sentence report as well, just as the unfortunate victim in the vehicular homicide can never come back to life, neither should his driver's license, and he wants to be cognizant of that fact, and he's well aware that it is a lifetime suspension and he needs to take that very, very seriously. He's also relayed to me that while he's been in the Lake County Jail, he's been informed that he has some sort of a heart condition for which he's prescribed some type of heart medication. He also receives lithium at the jail. He's been under the care of Crossroads and has had depression and anxiety. These have been struggles throughout his life, Your Honor. Not only that, due to the friction and issues in the home, it appears he's only obtained a 5th grade education.
The defense opens with a strategy built around context instead of denial. Nobody tries to erase the convictions because that would instantly destroy credibility. Instead, the focus shifts toward explaining how decades of instability shaped the defendant's decisions.
I don't think anyone else in here can even imagine what that would be like. It's not even the issue of going through 8th grade or 9th grade, but he hasn't even obtained the abilities that we take for granted, such as reading and writing. I'm sure that has made life frustrating and difficult for him as well. So he does indicate that if he were to be placed on community control, which is what he is asking for by this court, that he would go to 1062 Woodstock Road in Eastlake. There he has a friend named Anna Marie, and he would stay with her. He has some things there. He would abide by all the conditions that the court and probation department, the rules and conditions that would be prescribed for him, including not driving. He wants the opportunity to demonstrate to the court that he can lead a law-abiding life despite what indications might be gleaned from a review of his pre-sentence report, Your Honor. Thank you.
Mr. Tortorella, what do you want to tell me before I impose sentence?
I'd like to say, first and foremost, judges, I'm ashamed to be in front of you again. I do know the significance to driving under a lifetime suspension. I did, I got a charge of aggravated vehicular homicide many, many years ago, and a person that was dear to me died. And because of that, the judge imposed 9 years out of Cuyahoga. It was a Cuyahoga judge. Along with that sentence was a lifetime suspension. And I didn't realize at the time what that suspension means. Don Escape actually died from a decision I made, Your Honor, and I was granted my life back, my freedom. Therefore, my driver's license must stay to the world of the dead also. I also realized when a Cuyahoga judge imposed that kind of suspension on me, and I took for granted it was disrespectful to that judge. And with respect to this court, I'm going to say it the way I feel it. I might as well just have went ahead and slapped the damn judge in the face. I didn't know that then. I didn't realize that then. But I understand it now, and as far as that van, I could care less about it. I could show this court more that I could complete probation. No dirty urines, no catching cases. Whatever this court imposes on me, I will do. The stuff that my attorney has said to you is all true. You know, I also want to indicate to you at my age, I let a demon go many, many years ago, Judge. I don't want to find that demon again to survive being in the penitentiary. I don't have the health I used to have. And if I could be just given another shot to prove myself, I think that I can make this court proud. I will make the court proud. That's all I have to say, Your Honor.
Mr. Geigerich?
Thank you, Your Honor. State of Iowa Trust the Court to fashion a sentence that's appropriate and consistent with other offenders. Thank you.
All right, I've reviewed the pre-sentence report. You've got a long history of felony criminal offenses, serious, F1s and F2s. Went to prison on under one number on 3 separate burglary cases for 3.5 years in 86 to 89. Went back on a robbery in 94 until 01.
The judge begins reviewing the record. The emotional atmosphere changes completely. Personal history gives way to documented history, and documented history always carries greater weight during sentencing. The judge methodically reconstructs decades of convictions, prison terms, parole, probation violations, and repeated encounters with the justice system.
A couple months later, picked up a kidnapping and a felonious. Went to prison from 02 to 08, December of 08, December 1 of 08. December 25th of 08, an abduction, assault. Went to prison for that. For well, included in that was the vehicular homicide, aggravated vehicular homicide. So he went to prison for 8.5 years, lifetime suspension. Got out December 22nd of 17, so 9 years. 9 years you were locked up on that. Put on parole. Caught driving under suspension in June of 18, so 6 months after you got out in Menor, you were given a verbal reprimand, whatever the hell that means, by parole. And then in January of 21, another driving under suspension. The parole authority ordered you to follow all court orders and obtain your driver's license. So they weren't paying attention to much of anything, as usual. February of 21, you pick up an aggravated trafficking here. Put on probation, violated for methamphetamine. And then now we got this, October 18th of last year, driving under this suspension, this lifetime suspension. Less than 4 months later, driving under suspension again in Eastlake, both in Eastlake. So, in '09, you were given a lifetime suspension, and 4 times since then, you're driving under suspension. For some reason. Because you wanted to drive. I mean, that's the only reason, is because you wanted to. So you talk about following court orders. You don't follow orders. You wanted to go to McDonald's to get something to eat, so you went to McDonald's to get something to eat.
I never made it to
Well,
McDonald's.
that's where you were going. So the only reason the reason you report you got in the car is you wanted to get something to eat, and you got picked up. That was the second time. So, so you just keep doing it.
Not anymore, Judge.
What?
Not anymore.
You didn't what?
Not anymore, Judge.
Not anymore. You got a lifetime suspension for causing somebody's death, for which you served 9 years in prison.
Yes.
And since you got out of prison, you got caught driving under suspension 4 separate times.
I'm aware of that, Judge.
All right. Well, I want to make sure that you understand that, because you're telling me you won't do it anymore.
I won't. I promise you.
I don't
won't.
understand why you did it the first 4 times. I'm sure you did it more than 4 times. You just got caught 4 times.
I only had the van for 3 months.
Why did you buy a van if you had a lifetime license suspension?
To be honest with you, to stay in it.
Okay. Well, then you shouldn't have driven it. I don't know what to tell you.
One sentence quietly reveals why the court reaches its conclusion before the formal punishment is even announced. The judge reminds the defendant that he previously received a significant break in an earlier case, only to return with new violations. That observation transforms today's sentencing into something larger than these driving offenses alone.
I don't know what to tell you.
Let me show you, Judge.
What?
Let me show you, please.
What?
Please, let me show you, please.
You showed me everything you could show me when you're driving.
I understand that. Please, Judge. Please. I'll show you. I swear I'll show you.
All right, I've considered all the provisions in 29, 11, 12, and 13. And with the most disturbing, the most disturbing thing about this case is not necessarily your record. It's horrible, okay? But despite the fact that it was horrible, I gave you a break in 21 with the drug case. And now here you are again. Here you are again.
Judge, I will not disobey the law. I'll follow any instruction, please.
And
I don't have the help.
you don't follow instruction, or you wouldn't have been out there driving. You don't follow instruction.
I will, please.
You don't. Okay.
I didn't. But I will, please, Judge.
So I'm going to find you're not amenable to community control. On the 26/2/24, I'm going to sentence you to 12 months in prison. On the 26/2/25, I'm going to sentence you to 18 months in prison. Those sentences will be consecutive to one another. And I find that consecutive service is necessary to protect the public from future crime and for the appropriate punishment, and it's not disproportionate to the seriousness of your conduct and the danger you pose to the public, and your history of criminal conduct demonstrates they are necessary to protect the public from future crime by you.
The forfeiture of the vehicle serves as a practical ending to the case and carries symbolic weight beyond its financial value. Throughout the hearing, transportation represented repeated choices that ignored a lifetime suspension. Removing the vehicle eliminates one immediate opportunity to repeat that behavior. Courts often combine incarceration with measures designed to reduce future violations, and this fits that philosophy. This case illustrates one of the clearest divides in criminal sentencing: the difference between understanding wrongdoing and consistently changing behavior. The defense presented reasons to believe the defendant deserved another opportunity, while the prosecution relied on a history showing those opportunities had repeatedly failed. The defendant's remorse appeared genuine, but sentencing courts rarely decide cases based on sincerity alone. They weigh credibility against documented conduct, and documented conduct almost always carries greater influence. Every stage of the hearing reinforced that principle from a different angle. Personal struggles explained the past, but they did not erase repeated violations after prison, parole, and probation. By the end, the judge's reasoning centered on predictability rather than punishment alone. The final sentence sends a broader message, often seen in repeat offender cases. When promises repeatedly conflict with actions, courts eventually stop evaluating intentions and begin sentencing according to proven patterns.